Up next, we have Kate Lashorta with the University of North Texas Health Science Center presenting the impact of Daubert on forensic anthropology, expert witness evidence, challenges, exclusions, and the influence of research. Welcome, Kate.
So I think I just have a few questions here just to get some general insight on who's attending this webinar, and a couple of questions just to see if you can predict some of the information I'll be going over in this presentation, and we'll come back to these at the end. All right, interesting. I think that's all the poll questions we have for the beginning. And as I mentioned, I was taking notes on this, and we'll come back to those questions at the end of the presentation during the Q&A. All right.
Good afternoon. My name is Dr. Kate Lashorta, and my presentation will be focusing on Daubert and admissibility standards from a bit of a different perspective than most of the other talks. I'm a forensic anthropologist, and one of my main research interests over the last 10 years has been about how the Daubert decision has impacted the field of forensic anthropology. I do want to point out that while I do have a JD, I am not a practicing attorney. My previous practice was actually focused on pharmaceutical patent litigation rather than forensics or criminal law. While my presentation will review some case law, I want to emphasize that my approach to this topic is as a forensic anthropologist rather than an attorney. My focus is less on the in-court mechanics of how an admissibility challenge works and more on how forensic anthropology as a field has been impacted by admissibility challenges and how the field has reacted to Daubert. I know that the previous presentations have already provided a fantastic foundation about Frye and Daubert and all of the technical legal details, and they've all done a much better job of that than I ever could. So luckily, I get to focus on the intersection of these standards in general with forensic anthropology specifically. Today I'll be talking about 3 lines of research. When I first began studying forensic anthropology, my initial interest was in learning how often forensic anthropologists testify or present expert witness evidence in court, and how often they were subjected to admissibility challenges. That project led into research that shifted focus from case law and onto the peer-reviewed literature within forensic anthropology to see whether researchers had actually shifted their work towards more objective or quantifiable methods. And finally, I'll be discussing some qualitative analyses of the peer-reviewed literature to better understand why forensic anthropologists cite Daubert within their research. We'll first be looking at research drawn from case law to see how often judicial opinions reference forensic anthropology evidence, the topics that forensic anthropologists most often testify about, and how frequently forensic anthropology experts are subjected to admissibility challenges, and whether that frequency has changed since the 1993 Daubert decision. To find the case law for this first research question, I utilized several legal databases. I started this research back in 2013, and I've updated it several times over the years, so at different times I used searches in either LexisNexis or Westlaw, depending on which service I had access to, and I used their All Cases database. I also searched through Daubert Tracker as part of my initial search. In total, I've searched case law through the end of 2022. Through all of these searches, the first step was to find any available judicial opinions that used the term forensic anthropology or forensic anthropologist in some way. And then that initial dataset was further reviewed to limit it to cases where the reference was specifically to some kind of participation by a forensic anthropologist at some point during the case. I kept things pretty broad in this initial review, so this dataset does include opinions that mention forensic anthropology, even if that anthropologist may not have actually testified as an expert witness, but perhaps they worked with the forensic pathologist or law enforcement who may have relied upon the anthropologist's work in formulating their own reports or testimony. For all of these cases, I recorded who the forensic anthropologist was, if that was mentioned in the opinion, the specific topics that they testified or provided evidence about, and whether the opinion was specifically in relation to some type of admissibility challenge. There are, of course, some caveats and limitations to this approach. The first issue is about the breadth of data that I could capture. I was interested in seeing how often forensic anthropologists are involved in cases that progress to some kind of courtroom proceeding. Now, in order for those cases to appear in my searches, obviously, the case did have to progress to some kind of proceeding, whether it was a hearing or trial. That proceeding then had to produce a written judicial opinion, and that opinion had to actually reference forensic anthropology. There are plenty of medical, legal, and other investigations that involve forensic anthropologists that may not actually result in a proceeding or may progress to a proceeding but not result in a written opinion or an opinion that actually references their testimony. So my dataset certainly does not cover the entirety of the involvement of forensic anthropologists within medical legal investigations. Now, focusing on the opinions that I did capture in my searches, cases often produced multiple published opinions from different stages of the litigation. There were a number of instances where I could tell that the opinions were related to the same case, but I chose to leave these results in the dataset because the different opinions might be covering different aspects of the case or be referring to different aspects of the anthropologist's testimony or evidence. And finally, as I mentioned on the last slide, it was sometimes difficult to determine whether the judge was referring to actual in-court testimony versus a report that was attached to a motion or relied upon by other testifying experts, or whether the reference was to the forensic anthropologist's involvement during some earlier part of the investigation. In general, I opted to be inclusive to try and get the broadest sense of how forensic anthropology experts were being incorporated. In that initial dataset, I found 490 judicial opinions that referenced forensic anthropology evidence or participation in a case. The first case I was able to locate was from 1975, and the frequency rose fairly steadily to a high of 34 opinions that referenced forensic anthropology in 2018. This plot shows the overall frequency, but I also broke the data down according to what the forensic anthropologist was testifying about or what the topic was for their involvement in the case. The data showed a lot of different topics that forensic anthropologists have testified about. I've included the top 5 categories in this plot, which shows time along the x-axis and the number of cases on the y-axis. The biological profile is the estimation of age, sex, ancestry, and stature from an unknown individual's skeletal remains. Especially with the rise of DNA, in most recent cases that reference a forensic anthropologist's work in terms of estimating the biological profile, that estimation wasn't at issue during the criminal proceeding, but the data do show that anthropologists are still contributing these analyses to investigations. My guess is that this work may have been done during the earlier phases of the investigation before the decedent's identity had been confirmed. Positive identification, which is also referred to as personal identification, is identifying a set of remains as belonging to a specific individual. This is often done through the comparison of ante-mortem and post-mortem medical records. An example would be an individual who had a broken ankle that was repaired during their life with a surgical plate and screws. Their ante-mortem medical records might include a post-surgical radiograph, which could be compared with a radiograph taken of the skeletal remains to compare the placement and orientation of the plate and screws. Recovery relates to field recovery of the remains. Usually this wasn't the topic of testimony that was in dispute, but it was fairly often something that was referenced by the judge. Forensic taphonomy is the study of what happens to a set of remains after the individual has died or after the remains have been deposited in a specific environment. So this would encompass topics like the process of decomposition, the effects of animal scavenging, or the estimation of the post-mortem interval. Skeletal trauma and tool mark analysis was also a very common topic for forensic anthropologists. These analyses typically relate to ante- and perimortem skeletal trauma, which encompasses blunt force and sharp force trauma, as well as high-velocity projectile trauma like gunshot wounds. Skeletal trauma and taphonomy were the most common topics identified within the dataset of judicial opinions, especially looking at the data since 2000. I next examined the subset of opinions that were specifically related to an admissibility challenge to the forensic anthropologist. Since the dataset ranged from 1975 through 2022, I divided this into pre- and post-Daubert eras. This dataset does include both federal and state cases, so there are differing standards for admissibility challenges, which I've done my best to summarize in this table. From that first case that I found in 1975 through June of 1993 when the Daubert decision was issued, I was able to locate 14 challenges out of 49 total opinions issued within this timeframe that referenced forensic anthropology. Most of these challenges were related to the reliability aspect of the expert's testimony. However, the forensic anthropologist qualifications were also occasionally at issue, as was the relevance of the testimony to the actual issues of the case. There are a few interesting details that I want to point out here. The first is the relative rate of these challenges. Now, keeping in mind the caveats and limitations in searching legal databases that I discussed earlier, I found 14 challenges within a total of 49 opinions in this time frame. So the challenges represent roughly 29% of this subset of judicial opinions. Second, out of 14 challenges, there were 3 cases in which the forensic anthropology testimony was deemed to be inadmissible. 2 of these cases involved photographic comparisons. The third involved footprint analysis. One additional case, State v. Miller in 1988, held that the expert's testimony regarding the taphonomic analysis should have been excluded, but the admission of the evidence was not prejudicial, and therefore it didn't require a reversal of the trial court's determination. Finally, half of these challenges were from cases where a forensic anthropologist testified about a footprint analysis, which, when looking at the total data set, was not a common topic for forensic anthropologists to actually testify about. And I do think most forensic anthropologists today would not consider footprint analysis to be within the typical scope of our field. Out of the 490 total cases that I reviewed, only 10 involved footprint analysis, and 7 of those are included in the challenges listed here. You may also notice that for each of these footprint analysis cases that has an asterisk by it, and that's because each of these cases involved the same expert, Dr. Louise Robbins. Before her death in 1987, Dr. Robbins was a physical anthropologist who taught at the University of North Carolina. She testified as a forensic anthropologist in a number of cases and specialized in the analysis of footprints, boot prints, and even sock prints. I'm going to bring up a case that is not in that pre-Daubert challenge list, and hopefully you'll see why in a moment. Buckley v. Fitzsimmons was an opinion issued in 1990 in Illinois that initially stood out in this dataset because this was another case in which Dr. Robbins testified about a shoe print, although this particular case did not involve an admissibility challenge. During the investigation, there was an issue over whether a boot print found at a crime scene came from the defendant. At trial, Dr. Robbins stated that she could identify the wearer of a shoe with certainty even if she only had prints made with different shoes, and this was a direct quote from the judge's written opinion. The defendant was convicted but later released, and he filed suit that the parties involved in the investigation, including Dr. Robbins, had violated his constitutional rights. His complaint alleged that Dr. Robbins was, quote, an utterly disreputable witness for hire, end quote, to which the appellate court responded, quote, maybe so. Junk science is a plague in contemporary litigation, but the peddlers of poorly supported theories do not expose themselves to liability by doing research out of court or appearing in more than one case, end quote. And again, I'll remind you that admissibility wasn't at issue in this particular case. This course eventually made its way up to the U.S. Supreme Court in 1993 over issues of prosecutorial immunity. So again, the admissibility of Dr. Robbins' testimony was not at issue. In this opinion, the court noted that Robbins had provided the principal evidence against the defendant at trial. The defendant, who was the petitioner, had alleged that after experts at 3 different agencies had failed to make a reliable connection between the boot print at the scene and the defendant's shoes, the prosecution had hired Dr. Robbins, who was allegedly well known for her willingness to fabricate unreliable expert testimony. And that's a quote directly from the written judicial opinion. Following this statement, the court then included a footnote which quoted the petitioner's complaint, which had stated that Dr. Robbins' theories and reputation in the forensic community were generally discredited and viewed with great skepticism. Now, even though Buckley v. Fitzsimmons was not a case about admissibility of an expert witness's testimony, given those comments, I think it's really interesting to look at the dates these decisions were issued by the Supreme Court. Buckley v. Fitzsimmons was issued on June 24, 1993. Daubert was issued only 4 days later. So even though the Daubert case dealt with pharmaceuticals, I do wonder whether Dr. Robbins' testimony as a forensic anthropologist in Buckley was still present in the justice's mind when the Daubert decision was being written. So I think it is possible that forensic anthropology actually played a role in that Daubert decision. This slide shows all of the challenges to forensic anthropology expert testimony that I could find after Daubert. And again, I was looking at both state and federal cases, so a few of these cases did explicitly cite Daubert, but there are several other that cited state rules of evidence or state precedent that had adopted or codified Daubert either in whole or part. I've outlined those I was able to identify in purple. So most of these challenges are following Daubert either explicitly or through the incorporation of Daubert into state rules or precedent. For reference, in the pre-Daubert timeframe, my dataset included 49 total cases that were judicial opinions which referenced forensic anthropology expert witness evidence or testimony, and there were 14 admissibility challenges, representing roughly 29% of that dataset with 3 exclusions. In the post-Daubert timeframe, my dataset included 441 total cases with forensic anthropology expert evidence and 18 admissibility challenges, which is only about 4% of the dataset, and this included only 2 exclusions. Both of these exclusions were regarding photographic comparisons, which, as a reminder, 2 out of the 3 exclusions prior to 1993 were also related to photographic comparisons. There were also 2 other cases in which photographic comparisons were challenged, but still deemed admissible. When I look at this data, and remember, I'm looking at this as a forensic anthropologist, not as a prosecutor or defense attorney, I don't really see a big change in that post-Daubert era. When you take out the more unusual topics of testimony for a forensic anthropologist, so things like photographic comparisons or footprint analyses, and focus instead on the core areas of forensic anthropology, things like the biological profile, positive identification, taphonomy and postmortem interval estimation, and skeletal trauma, I don't see any real change in the frequency of admissibility challenges or exclusions. There were multiple cases in which the judge elected to leave the decision to the jury in terms of how much weight to give the expert's testimony rather than wholly excluding the testimony. And overall, given the wide variety of cases that forensic anthropologists are involved in, there really don't seem to be hard or fast rules that practitioners can take away. These admissibility evaluations have been flexible. The Daubert factors are flexible, and the court has recognized that not all of those factors would be applicable in every case. Any challenges to forensic anthropology expert testimony seem to be very dependent on the specifics of each case. Now, when I initially presented some of this data at a conference in 2015, I ended with the following conclusion. Regardless of Daubert, forensic anthropologists will always need validated objective techniques to remain a viable resource in medical legal contexts. I focused on the word objective because this led into the next phase of my research. In the aftermath of Daubert, there were a number of forensic anthropologists that began calling for a paradigm shift within the field to move towards more objective and quantitative techniques to ensure that our expert testimony wouldn't be at risk to Daubert-type challenges. My next research question was whether there actually had been a shift within the published literature away from subjective or qualitative methods and towards more objective and quantitative methods. There were a number of publications that provided reviews of Daubert and the Daubert trilogy and how these decisions might impact the field of forensic anthropology. There were also calls like this quote from Dirkmaat et al. In 2008, which stated that data analyses using quantitative methods are preferred over those employing qualitative methods. The testability and reliability of methods are necessary to establish that the conclusions are objectively arrived at rather than subjectively determined. And while I wholly agreed that forensic anthropologists should be focused on validated, reliable methods, I wondered whether there were any measurable changes in terms of how research was being conducted and the types of new methods that were being developed in response to Daubert. To answer this question, I looked at the entire body of forensic anthropology research that had been published in the Journal of Forensic Sciences, which I will often abbreviate as JFS. JFS is the flagship journal for the American Academy of Forensic Sciences. I reviewed articles that had been published in JFS between 1972 and 2020. My dataset was comprised of 1,142 articles, which I had reviewed either the abstract or full text of in order to confirm its relevance to forensic anthropology. The main category of articles that I ended up excluding from this study were forensic odontology and dental anthropology. Each of these articles was coded according to its general subtopic within forensic anthropology, whether the article described an analytical method that could be used in a medical legal case, and then the type of data that was being used. In terms of topics, the most common topics of publications were similar to the most common topics being testified about: biological profile, taphonomy and PMI estimation, skeletal trauma and tool mark analysis, and positive identification. Facial approximation was also a common topic. Biological profile articles were the most common, representing about 36% of the total number of articles, so I decided to focus on this subset. When I talk about types of data, I mean whether the data could be categorized as quantitative versus qualitative or objective versus subjective. Now, of course, there's a lot of overlap between these categories, and these terms can be defined in different ways. For this study, I defined quantitative data as permitting some type of quantitative data analysis, meaning that the data were recorded as a number. Qualitative data had no numerical attribute or inherent structure. Categorizing data as either objective or subjective was related to whether the data was definitive in some manner, and articles could be coded as having any combination of these data types. To give a few examples, quantitative and objective data would be something like the measurement of a bone, like the width or breadth of the skull. Quantitative subjective data could be using an ordinal scoring system to score a morphological feature of the skeleton, like the relative size of the mastoid process. The use of a numerical ordinal system still made the data quantitative, but it would be more of a subjective decision up to the individual anthropologist as to whether the feature was more similar to the description or template image of a 2 versus a 3. Qualitative objective data would be a text-based description of a definitive feature. So a statement like, the iliac crest epiphysis is not fused, which is a non-numerical but definitive state. And finally, qualitative subjective data would be something like an assessment of whether the face of the pubic symphysis has a billowy surface. As discussed earlier, after Daubert, there was a general call within forensic anthropology for research to become more quantitative and objective in order to more explicitly adhere to the Daubert criteria. Using the subset of articles that discussed methods for estimating parameters of the biological profile, my question was whether this shift had actually occurred. As a reminder, the main parameters of the biological profile are estimations of an individual's age, sex, ancestry, and stature. Methods for each of these parameters use different features that can be recorded in different ways, so I did separate out the data into those 4 categories. Here we're looking at plots with year on the x-axis, and there's a vertical dashed line at 1993 to indicate the Daubert decision. And then there's proportion on the y-axis for whether the data collected in that study was either quantitative in green, qualitative in yellow, and in purple you'll see that there were several articles that did collect both types of data. I performed chi-squared proportional trend tests and found that there was a significant decrease in the number of qualitative data articles for both age and sex estimation. So this was a positive indicator that the field had been moving towards more quantitative methods in compliance with Daubert. However, when those same articles were coded as objective in green or subjective in yellow, I actually saw almost no difference. The only significant difference was in ancestry estimation articles, which actually showed a significant increase in the proportion of subjective data-driven articles. There was no significant change in the proportion of objective versus subjective data for either age or sex estimation articles. The final characteristic that I looked at was whether there had been a change in how often studies performed some kind of observer error study. These graphs are coded as either intra-observer in green, inter-observer in blue, both types of error studies in yellow, and neither error study in purple. For the statistical trend test, I grouped the intra, inter, and both categories together, so I was looking at the trend of whether at least one kind of error study had been performed, and there was actually a significant increase for age, sex, and stature estimation research. There was no significant change for ancestry research, although I will note that was the smallest sample size, so that may have limited the power to detect a difference. So what does all of this mean? As a whole, despite initial calls within forensic anthropology for a shift away from qualitative methods or the use of subjective data, the field really hasn't changed much in terms of the types of data being used and collected for analytical methods. However, there has been a significant increase in the inclusion of observer error studies. For forensic anthropology, we need to keep in mind that nothing within Daubert or any subsequent decision requires that experts only use methods based on quantitative or objective data. While data that is quantitative in nature can be more readily amenable to certain types of statistical analyses, qualitative methods can still be highly accurate and very reliable. And in a field like forensic anthropology, not everything can be reduced to an objective or quantitative measurement. And I love this quote from Christensen and Crowder in 2009. Quantitative data is based upon qualitative judgments, and all qualitative data can be described and manipulated numerically. Categorizing data along these binary lines of qualitative versus quantitative or objective versus subjective is not as clear-cut as we might like to think, and having qualitative aspects to a method should not be viewed as a negative attribute or something that inherently makes a method more vulnerable to admissibility challenges. From my perspective, I believe that we should focus less on trying to interpret Daubert or meeting a checklist of Daubert factors within the context of our research and method development, and instead focus on ensuring that we as forensic anthropology researchers are adhering to principles of doing good science. I think the data showing the increase in observer error studies does show that we are focusing on good science, and we should be doing this because we're scientists, not because we're trying to avoid a hypothetical future Daubert challenge. Now, I'm certainly not the first one to say this, but as you hopefully will see in the next section, this idea doesn't seem to have been fully adopted within the field. I'll use this last idea as a jumping off point for the next phase of my research. As I was analyzing the data, I saw that, as a whole, the field really hadn't shifted towards the more exclusive use of quantitative or objective methods. In my mind, this wasn't a problem. With the flexibility of Daubert evaluations, using qualitative methods that might rely on more subjective assessments was not an inherently bad thing, again, so long as forensic anthropologists were basing those methods on sound scientific principles. However, I saw a bit of juxtaposition between what the data were telling me and how Daubert was actually being discussed within the forensic anthropology literature. My next questions were about how often Daubert or other admissibility standards were being cited within the published forensic anthropology literature, and more specifically, how Daubert was being framed within the context of our research. For this study, I used the same initial dataset of forensic anthropology articles that had been published in the Journal of Forensic Sciences between 1972 and 2020. But I now focus on the articles that cited, discussed, or somehow referenced a legal admissibility standard for expert witnesses. I ended up with 123 articles. I did take a fairly broad and inclusive approach to arriving at this final dataset. There was quite a lot of variability in terms of how directly an article might reference an admissibility standard. An article could directly cite Daubert, or it could make more vague references to using scientific principles that are acceptable within courts of law. There was also variety in terms of the depth of the discussion. Some articles might include a single citation to Daubert without any direct discussion, while other articles were entirely devoted to a theoretical analysis of the impact of Daubert within forensic anthropology. Obviously, since my dataset went back to 1972, this analysis captured articles that reference standards other than Daubert. This plot shows the total number of forensic anthropology articles published in the Journal of Forensic Sciences in purple. Articles that specifically cited or referenced Daubert are in light green, and articles that referenced some other admissibility standard or perhaps cited a standard without specifically mentioning Daubert are in teal. Out of the 1,142 total forensic anthropology articles, again, there were 123 that cited an admissibility standard, with 85 of those specifically citing Daubert. I'm now going to overlay this plot with a timeline of some events that I think give the data more context. As we already discussed, the first judicial opinion that referenced forensic anthropology expert evidence in my data was in 1975. The first article in JFS to reference a legal admissibility standard in relation to forensic anthropology was published in 1982. Daubert, of course, was issued in 1993. 2002 marked the US v. Liera Plaza case, where a district court judge ruled expert testimony on fingerprint evidence to be inadmissible. This decision was very quickly reversed, but this seems to be an instigating event that started making forensic anthropologists concerned about the implications of Daubert. The first articles that referenced Daubert were published in 2004, so fairly quickly after that Plaza decision. And then the last event that I think contributed to forensic anthropologists' general awareness of Daubert and a growing concern over the potential impact was the 2009 report on strengthening the forensic sciences within the United States. What I see in this data is an initial 10-year lag between the Daubert decision and the first citation to Daubert within the forensic anthropology literature in JFS. Now, these citations started to grow and reached a peak after that 2009 report. A chi-square test of trend in proportions does show a significant increase in the proportion of forensic anthropology articles that reference admissibility standards over time, and that seems to be fairly sustained over the last decade. I wanted to dig further into why forensic anthropologists were discussing these standards within their research. To do that, I did a qualitative thematic analysis of those 123 articles. Thematic analysis is a flexible qualitative research method that allows for the identification, organization, and analysis of themes within a text-based data set. And I approached this without a preconceived hypothesis, as I wanted to allow the patterns to emerge more organically from the data. This analysis was an iterative process that consisted of reviewing the text of each article to note why and how the admissibility standard was being discussed in order to generate an initial set of codes. Those codes were reviewed for commonalities, and they were refined and standardized by returning to the original text as needed. Natural groupings of these codes emerged as themes, and the dataset was reviewed a final time to ensure matching of the original text's codes and themes. The themes that emerged were not mutually exclusive, so articles could be coded as containing more than one theme within their discussion of admissibility standards. In total, I identified 8 themes. Most commonly, there was a general discussion of the legal admissibility framework. Often, this might include a listing of the Daubert factors within the introductory section of an article. Authors would also frequently cite an admissibility standard to provide context for the reported results, and this might be something like describing how the reported method might meet certain Daubert factors. Authors also used admissibility standards to justify why the research being described was needed within the field. Others would frame previous research or the general state of forensic anthropology within admissibility standards, perhaps to point out a potential or hypothetical deficiency in an existing method that might be vulnerable to an admissibility challenge. And then less often, authors would use admissibility standards to advocate for the need for future research, discuss the use of a particular method within a specific court case, perform a very in-depth theoretical analysis of Daubert within forensic anthropology, or they would discuss those standards in relation to the training or role of forensic anthropologists. Here's a look at how these themes occurred over time, and the main result that struck me was that the theme of using an admissibility standard to justify the research being described in the article didn't appear until 2004, which, as a reminder, that's when Daubert began being specifically cited within the forensic anthropology literature. Now, this perceived need to justify research might be related to what I think is a fundamental misunderstanding of Daubert within the field of forensic anthropology. Examples of this misunderstanding could be found throughout the forensic anthropology literature in language that exceeded Daubert. Almost half of the articles that cited Daubert in this dataset used some kind of constraining language, like referring to the Daubert factors as criteria, or stating that one or more of the factors were required. Other authors went further and added a requirement for strictly objective or quantitative methods that doesn't actually exist within the specific language of the Daubert decision itself. So I've listed a few examples on this slide. One author stated that the Daubert criteria require methods to be scientifically tested, reliable and replicable, and therefore objective and quantitative. Another author stated that forensic anthropologists who testify in court must show that their methods are empirical, objective techniques that have been repeatedly tested and peer-reviewed. A final example stated that without quantifiable data, there are obvious implications for the certainty with which even the most highly trained anthropologists can support their assessments in court. There were also some interesting results when I looked at the breakdown of articles by subtopic. Biological profile articles, again, were the most common topic across the entire dataset. And these articles were also proportionally more likely to discuss admissibility standards than articles related to taphonomy or skeletal trauma. And this was particularly interesting because, again, especially in recent years, the identity of the decedent is usually not at issue by the time a case progresses to legal proceedings. But as we saw in the initial analysis of case law, forensic anthropologists are still often including aspects of the biological profile within their contributions to the initial investigation, which may be discussed at trial. Even though this testimony is very unlikely to be at issue or be the subject of an admissibility challenge, these results still highlight that we need valid and reliable methods regardless of whether those results would be at issue during a court proceeding. It was also notable that the articles related to taphonomy and skeletal trauma are less likely to address admissibility standards, even though these topics are among the most common topics for forensic anthropologists to testify about in court. Now, this may be a reflection of the fact that we continue to use descriptive or qualitative methods to analyze topics like decomposition or skeletal trauma versus using more quantitative approaches. And while my reading of the case law says that qualitative methods are not inherently problematic under Daubert so long as they're developed using sound scientific principles, it seems that there's still a lingering concern about this in the field. So perhaps researchers that are publishing articles about taphonomy or trauma may be hesitating to mention Daubert because they may not know how to best frame their research as fitting within that admissibility framework. Having been thinking about Daubert in the context of forensic anthropology for about 10 years now, and looking at all of the data that I've presented today, I think that forensic anthropologists and researchers first need to remember that judges are the final arbiters of admissibility, not us. We can make statements in our research that some new method would satisfy Daubert or meet certain Daubert factors, but that ultimately is going to be the judge's determination if that issue were to ever come up in court. Second, we need to relinquish the hyper-focus on trying to completely quantify the discipline. We deal in observations of human variation when we try to estimate the parameters of the biological profile, and we deal in interpretations when we evaluate skeletal trauma, and there will always be some degree of uncertainty and subjectivity within those assessments. We should embrace both qualitative and quantitative data, observational and experimental studies, and methods that use both metric and morphological characteristics, so long as those methods are founded on the use of appropriate scientific principles. This includes focusing on structured research design, well-defined and standardized methods, evaluations of accuracy and precision, appropriate training, and independent peer review of casework. While Daubert was a good impetus for evaluating our methods, forensic anthropologists don't need to invoke Daubert to justify doing good science. We should be aware of Daubert, but remain wary of letting Daubert constrain how we design research and ultimately advance our field. I have to acknowledge my collaborators and funders for this research. Adrian Keelish was my fantastic graduate student research assistant who did a lot of the legal database searching and organizing the case law. Dr. Angie Christensen worked with me on the interpretation of the thematic analyses and has truly been invaluable in framing Daubert within forensic anthropology. My approach to this topic has definitely changed over the course of my research, and Dr. Christensen has been instrumental in that change. And much of the work that was presented today has been supported by the National Science Foundation and the National Institute of Justice. I also want to thank the Forensic Technology Center of Excellence for inviting me to present as part of this workshop, and I also want to thank you for attending and listening to this presentation. I've included my email address if there are any follow-up questions, and hopefully I've timed this properly and we now have time for questions during the Q&A.
Hi, Kate. Thanks so much.
Thanks.
Yes, I'm glad that you were able to quantify all this data and actually, right, because I suspected it had a huge impetus with the NAS report. And you were seeing that everybody wanted like to quantify everything that's not even quantifiable.
Yep.
And like you said, I, in my 20 years here in North Carolina, I have never testified on the biological profile. It's always trauma or PMI. And
Yeah,
those
that's
are the
certainly
more qualitative areas, right? Which is
Yes.
interesting.
Yes, yeah. As you saw, taphonomy and skeletal trauma tool mark analysis are certainly the most common types of topics for testimony, especially that's kind of in the post-2000 range. I was surprised there are still a number of judicial opinions that do mention some aspects of biological profile, even recently, but I think as I alluded to, those really aren't the areas that are at issue. They may have been mentioned in the expert's report or taken place during the early phases of the investigation, but it's really not what's at the core of the testimony and certainly not of any potential Daubert or admissibility challenges.
Right. So should we get the poll results so we can discuss those?
Yeah, I jotted down a few notes, but do we have screenshots of those results or can we show those again?
Here we go.
Yes. So first question was just, what is your current field or position? This was just more for my my understanding. I kind of wanted to get a handle on who the participants were, and it looked like we have was like 82% of thank you were forensic scientists, which is fantastic. I was sort of anticipating a lot more attendance from the attorney side, so that's great. And we have 4% of forensic anthropologists, so hopefully they found some of this particularly useful. Fantastic. And question 2. All right, so this is, what topic did you think forensic anthropologists most often testified about in legal proceedings? And it was kind of evenly split, but most people were correct. So skeletal trauma and things like taphonomy, decomposition, estimation of the postmortem interval, those are certainly the most common topics that we see being testified about. And then I believe question 3 was same answer choices, but the question was now, which topic of testimony do you think is most often subjected to admissibility challenges? And this was interesting. So people still kind of went with skeletal trauma and taphonomy decomposition, because I think that's an absolutely rational thing to think that if these are the topics that are most commonly testified about, that's what we would see as the most common admissibility challenges. But actually, those are relatively minimal in the terms of the challenges. And actually, we saw much more proportionally for things like footprint, shoe print comparisons, which probably I think a lot of people might not have selected because they don't really think of that as being part of that kind of traditional realm of forensic anthropology. And same thing with photographic comparisons, even though we saw a number of challenges and those made up the bulk of the excluded opinions. That's not really what most people, I think, in the field of anthropology think of kind of within our realm.
Yes, and after Louise Robbins did that whole fiasco, we all like, nobody looked at that again.
Yeah, and then questions 4 and 5, I just tried to give some very short, obviously very, very brief summaries of a few cases that I found, just to see if you could predict or think about what might be admitted or excluded. So this first one, forensic anthropologist who specializes in the comparison of boot prints. I won't read the entire thing, but it was basically the comparison of boot prints. Maybe after the presentation, if you weren't aware before, this was certainly alluding to Dr. Robbins' testimony. And this case summary could actually be applied to both that Buckley v. Fitzsimmons case, which again wasn't an admissibility challenge, but certainly I think the court alluded to that in their opinion. But this is also a summary that could apply to, it was People v. Ferguson, which was from 1988. And that was the one footprint analysis that was actually excluded in that pre-Daubert data set. And then number 5, so this was about really the differentiation between perimortem and postmortem trauma, especially when recovery involves heavy earth-moving equipment. 81% of folks said this was admissible, and that is correct. This was EPES v. State from 2019. And yes, there was actually an admissibility challenge, but this was deemed admissible. I think that's it for poll questions. But yeah, hopefully folks found those a little bit interesting to think about as the presentation went along.
Yes, so we have several questions in the Q&A section. When discussing pre-Daubert admissibility challenges, photographic comparisons comprise some of the inadmissible evidence. Is this topic generally more accepted now post-Daubert, especially with the increase in technology use over the years?
That's a great question. And I'll be honest, one that I probably cannot fully address because again, photographic comparisons came up in my data set because these were individuals who specifically identified themselves as forensic anthropologists and said this was their area of expertise. So I can't really comment on photographic comparisons as an entire field. It was really only focused on when it was a forensic anthropologist testifying in that regard. And so I think in the post-Daubert data set, there were still a few instances of forensic anthropologists doing these types of comparisons. Those were the 2 cases where the evidence was deemed inadmissible. So it is still happening. We do have forensic anthropologists that do still make these comparisons, but I can't speak to it as a general topic.
And just to clarify, when you mean photographic comparison, are you talking like actually trying to identify someone from photographs or?
Yes. So an example of cases would be making a comparison or trying to determine whether the defendant was the person that was seen in a surveillance photo or surveillance
CCTV
video.
Or something.
Right. Yes.
Yeah. Interesting. Yes. I run away from that myself too.
Yeah, I think and this is, I think, one of the interesting things from my findings is across the entire data set, really what we see being challenged and what we see being excluded are not those kind of what I think of as the core areas of forensic anthropology.
Yes.
So things like skeletal trauma and taphonomy are really not being challenged very much at all. And the few times that they are being challenged, they're still being found admissible. It's really these sort of outer, almost fringe topics that
Right.
are really being challenged more and being excluded.
Not our bread and butter.
Right, yes.
All right, here's the next one. In your opinion, why was there an approximate 10-year gap between Daubert decision 93 and the first forensic anthropology publication citing Daubert legal standards specifically?
Yes, so I will just mention that my data set was really only on articles published in the Journal of Forensic Scientists, so it's certainly possible there were other articles about forensic anthropology and other publications in that interim. But in that timeline that I showed, I think the issue is Daubert was issued in 1993. The first time we saw a citation to Daubert within a JFS article was 2004, but that was very shortly after that 2002 US v. Lara Plaza case, which was the exclusion and then a quick reversal about the admissibility of fingerprint evidence. And so from my reading, it seems like that was really an impetus to kind of like a wake-up call that some of the forensic anthropologists got a hold of.
Publication in JFS that, because it has a broad forensic science audience.
Yes.
Okay, that makes sense. Another question is, why do you think misunderstandings of the Daubert standards tend to emphasize the need for more objective and quantitative data and a paradigm shift away from more qualitative and subjective techniques in forensic anthropology?
Yeah, so I think in that kind of aftermath of Daubert and that initial kind of 2004 time period, there was kind of a really heavy pendulum swing. Whereas, the early days of forensic anthropology, there were some references to it being more of an art than a science, and certainly a more heavy reliance on methods that probably wouldn't be described as particularly rigorous under today's standards. And so I think with Daubert, there was some fear, and that pendulum really swung in the opposite direction, and maybe I would say too far in that direction. So they were trying to completely quantify things. But, personally, I don't think it's possible or even desirable to completely try to quantify everything within forensic anthropology. And I think hopefully we're seeing that pendulum kind of swing back to a more even understanding and a better understanding of the context of anthropology within the framework of good science as well as Daubert. Yeah,
it's like trauma analysis and forensic anthro. It's akin to, tool mark analysis, right? It's pattern analysis. It's difficult, if not impossible, to quantify. So another question is, what do you think are the biggest research needs in anthropology to aid admissibility?
I think we need to, I'll just address it first from the idea of it. Our research shouldn't be directed at trying to aid admissibility. I think that's a theme that I was hopefully trying to get across in this research, is that when we're thinking about research and designing our research, it shouldn't be because we're trying to meet Daubert or we're designing a research project in a certain way to meet the Daubert criteria, because they're not criteria. They're simply factors that judges can evaluate. So I think we just kind of need to shift our thinking a little bit and get away from that mindset is that we're doing something to aid admissibility. I think in general, as long as our research is being founded on solid scientific principles, where we're thinking about good research design, and it could be experimental, but also I think there is a lot of value in observational studies and learning from case studies. There's nothing inherently bad or wrong about that type of study or those types of knowledge. As I said, I think doing things like observer error studies, which can certainly be done with some of the more qualitative type methods, those are great studies. We can always have more of those. But I think we want to get away from trying to justify the research that it's needed just because of Daubert.
Yes, and the other two are more of commentaries, thanking you for your great presentation and thinking from the perspective of the defense counsel and available evidence and things like that. So yeah, very positive feedback for everything.
Thank you.
And if we do not have, does anybody have any more questions or additional questions that we can ask? If you do, Kate presented her email and the presentation, so you can email her, and then Erica actually just posted it in the chat. So, and all the presentations will be posted on the FTCOE website as a PDF, so you'll have the presentations, and in a couple weeks, the presentations themselves will be archived. As a final reminder, I'd like you to not forget that part 2 of this workshop, which is the FRI workshop, will be on October 25th, if you're interested in attending that. And I hope to see everyone soon in October. And thank you again, Kate.
Thank you.